Good morning and good afternoon, everyone. Welcome to our Commercial Litigation Group webinar, Commercial Crossroads, Landmark Decisions Shaping Litigation Risk for In-House Counsel. We're very excited to have you with us today and want to take you through some of the legal developments in the past year that'll impact your business. By way of introduction, my name is Kaleigh Milinazzo, and I'm a partner in the Commercial Litigation Group in Vancouver. Before I introduce my co-presenters, I'd just like to take you through a bit of administrative information that's outlined on the screen in front of you. I've been told to remind you about two important things. The CPD certificates are available through a link and QR code that you'll see at the end of the seminar. And we also have a survey tab, which we'll ask you to complete at the end of the presentation, so we're able to get your feedback on how we can best help you next time. With me this morning are three of my partners. The first is Arif Chowdhury, who's a partner in our Calgary office. In addition to his general practice, Arif has specific expertise in international arbitration, pension law, and has appeared before a number of administrative boards, including the Sports Resolution Centre of Canada. Also with us this morning is Jessie Harper. Jessie is a partner in our Toronto office, and Jessie's practice is broad and includes all aspects of civil litigation and arbitration, with a particular focus on complex commercial disputes. Representing the Quebec region is Sébastien Richemont, who's a partner in the Montreal office. Sébastien's main area of practice is class action, shareholder dispute, contract litigation, and securities matters. And Sébastien will kick things off for us this morning with a case law update from Quebec.
Thank you, Kaleigh. So I've chosen to talk about three cases this morning or afternoon. And I thought that those cases would not only interest Quebec Counsel, but as well Counsel across Canada, because the two first cases deal with unanimous shareholders agreement, and basically the statute, the federal statute and the provincial statute are really the same, and the rules are very similar. So I think the takeaways and what we can learn from those two first cases can be applied across the board. The third cases I've chosen is a case about arbitration clauses, and once again, that's something that will be of interest for anyone, I think. So next slide, please. So the first case, Cassette against a number company, that was a case issued by Justice Sheehan, who's a former Fasken partner, a well-respected judge on the commercial list in Montreal. The case was a shareholder dispute, and basically it was a typical family company dispute. The founder, the father, had passed away and had left a ton of money in the company before he passed away, and a significant amount of money was owed to a subsidiary for which he was the sole shareholders. But for the main operating company, there were other shareholders involved, minority shareholders. And the issue was really about, and that's really the point of this case, was about what is a unanimous shareholder agreement. We know everybody is familiar with those agreements, especially in private company. Those are very important to determine the board composition, investors' vetoes, right to information and restriction. And in this specific cases, the issue was what to do with those really big surpluses, the cash that was in the company. And what had been done by the estate of the father was to basically reimburse, take the money in the company and reimburse all the the amount that were owed to the subsidiary. And that deprived the other minority shareholder of a really significant amount that they could have. So the minority shareholder were basically alleging. Well, we can maybe go to the next slide, Andrea. So the minority shareholder says that they were entitled to some distribution of those big surpluses on the basis that there was an agreement between the shareholders in place, which indicate how the surpluses should be distributed. Some was to be paid to the father's company, but another portion was to be distributed to the minority shareholder. We're talking about tens of millions of dollars in that case, and obviously that was a very good ground for litigation. So on one end, they said they were trying to enforce the shareholder agreement. And on the other end, the defendants were basically saying, well, the shareholder agreement was not signed by one of the shareholder. It was signed by everyone but save one. And therefore, it's not a unanimous. And therefore, it cannot binds or restrict the power of the board of directors to issue their discretion over dividends, which is the typical rule. So just to keep in mind, a unanimous shareholder agreement, basically what it does, it is the only way to remove from a board of directors the power it has over the management of the company, including issuing dividends. And in that case, the board had agreed to reimburse the father's company debts and pay the money. So the board had made a decision which was not in line with the shareholder agreement. So really the question that the court had to look at is whether this was a unanimous shareholder agreement. So we can go to the next slide. So in that case, even though the plaintiff were trying to make the argument that there was kind of an implicit agreement by the one shareholder that did not sign the agreement, that he was in agreement with it, the court relied on the behavior of the party and really the fact that there was a missing signature on the agreement to say, well, there is a strict requirement that a unanimous shareholder agreement be unanimous. If it is not, it has absolutely no power over the board of director and cannot remove the powers of the board of director. And therefore, and the rule is the same under the Federal Act as well. I would presume under the Provincial Corporate Act as well. And so therefore, without such an agreement, unanimous shareholder agreement, the board of directors was fully entitled to do whatever they want with respect to issuing this dividends. And in that case, they did not issue the level of dividends that the plaintiff were seeking, and it was fine. It was not found to be oppressive. Next slide, please. So the takeaways, obviously, the rules, corporate rules, remains to restrict the boards of directors' power under corporate law. Shareholder agreement must be signed by all the shareholders, and that, I mean, I think everybody in the practice, either litigation or corporate practice, it's a stark reminder that this is a strict requirement that needs to be followed and not to be left for a later day. As well, I mean, and we have to keep this in mind in any steps, because sometimes unanimous shareholder agreements are modified. So if you want to modify it, amend it, well, once again, you need everybody's signature to do it, because if you don't, you might have a problem down the road. And from a litigator side, well, just do not take for granted that an agreement between shareholders is binding unless you're sure that everybody has agreed to it, every shareholder. of every class of shares. So once again, the second takeaway is that, well, if there's no unanimous shareholder agreement. Obviously, the board retained discretion over all the decision regarding the company, including the issuance of dividends. And that's as well, we have to keep this in mind. Even when there's a shareholder agreement, there might be some issue of the validity of the shareholder agreement, and the governance of the board and the decision of the board has to be as well in line with what we expect that it should be done in the proper way. And in that case, so it was an oppression case. An oppression remedy were sought. All kinds of arguments were trying to be made as to the fact that the payments or repayments of the debt of the father's company were oppressive somehow, and the court as well reminds the rules that we all know that, well, to have an oppression remedy, although it's a claim in equity in some form, there's a threshold to be met to obtain oppression remedies. And in fact, if a board is within its limits and issuing its power, unless there's a clear breach of the reasonable expectations of the party, the court will not intervene. So that's the first case. We can go to the next slide. So here's what's interesting about this case is that it's a kind of a counterpoint to the previous case, meaning that in that case, three partners started a real estate project together, put a company, and decided to start the business of building condos, real estate. And initially, it was envisioned that there would be a unanimous shareholder agreement, but one of the shareholder was finding excuses, although the proof was that everybody was basically in agreement with what was in a draft that was circulated by the notary between the parties. One of the shareholder was making excuses not to sign the shareholder agreement, and when in every good project there are disputes, and obviously more so if there's no contract signed. So at some point, one of the shareholder was basically doing all the work. He was a carpenter and he was investing a lot of his time in the project. And meanwhile, the other shareholders, although they had put money, were just basically paying themselves interest on the money they've invested without being involved in the company. And at some point, they've just decided to sell the project before it was terminated without the consent of the third partner. So that led to litigation. And Mr. Allaire, who was the carpenter, made an oppression claim based on the basis that basically he had been working for the company, investing by his time, his work to build the real estate without being paid. And decisions were made without him approving the decision, namely selling the project. And one of the issue was that the shareholder was not signed, but he said he had reasonable expectations that the unanimous shareholder agreement be signed, and therefore, by not signing it, one of the partner was oppressing him. So if we go to the next slide. So yeah, so I've already mostly covered that. So he was claiming for unpaid construction work. Yeah, we can go to the next slide. So the court came to the conclusion that, in fact, there has been oppression, and I think the interesting point is that by not signing the unanimous shareholder agreement, the court found that the partner behavior was oppressive, and that was one of the grounds to provide remedies to the plaintiff in that case. So going back to the previous case, we saw that, well, it's very important that we have a unanimous shareholder agreement, but you cannot just neglect to sign to try to benefit from the fact that the agreement need to be unanimous. I mean, there's still a need to be in good faith and not let the other partner believe that you're going to sign the unanimous share agreement, let the project start, let the money be invested, and then all of a sudden not try to invoke the fact that the agreement is not in place. So as well, other oppressive behavior was selling the company without the partner's consent, although they had agreed that it would be unanimous on that hand, paying them self-interest at a higher rate than interest was paid to the third partner, and not paying him for his work was also found to be oppressive. We can go to the next slide. So once again, taking the two cases together, very important to have before starting a project or investing in a company. Make sure that all the agreements are in place, properly signed, because it is a recipe for disaster if not, and that would extend to trying to play on the fact that the agreement is not signed to try to get some benefit out of it. I mean, obviously, once again, in those cases, in oppression cases, good faith is very important, and parties needs to behave accordingly. So that's covered the first two cases on unanimous shareholder agreement. We can go to the next slide. Now we're talking about arbitration and specifically arbitration clauses. In that case, it's a case between Hydro-Québec and Terrassement Saint-Louis. So Hydro-Québec had a contract, standard form contract with Terrassement Saint-Louis with respect to environmental rehabilitation of a site with contamination. Hydro-Québec allegedly failed to pay some amount owed to the contractor. So the contractor initiated a claim for $250,000 in the Chicoutimi against Hydro-Québec, and Hydro-Québec in response said, well, in the contract there's an arbitration clause, and as well it needs to be, if there is litigation, it needs to be in front of the Montreal courts and the atonement of jurisdiction for the Montreal tribunals. And really the sticking point here, well, we can go to the next slide. The sticking point was that the arbitration in that case was the arbitration clause said that a panel of 3 arbitrators would be dealing with the matter. And obviously, we're seeing the amount at stake, that would not make any sense to go in front of a panel of 3 arbitrators to litigate a $250,000 claim. So the Terrassement Saint-Louis, what basically they said, well, it's an adhesion contract, and therefore, and it's abusive because it's basically depriving them the right to go in front, to have their matter litigate. It was cost prohibitive and they cannot move forward. They try to make the same argument as well as going in front of the Montreal court instead of the Chicoutimi court. We can go to the next slide. So well, that's something maybe more specific to Quebec, but it was found to be a contract of adhesion, mainly because the terms were imposed by Hydro-Québec on its subcontractor. And in Quebec, if a contract is a contract of adhesion, the court is entitled to intervene in case the clause is abusive. And the court found that for such a small claim, going in front of a 3-arbitrator panel was an abusive process, and therefore decided not to grant Hydro-Québec motion to refer the matter to arbitration. Although on the second hand, though, they found that going into Montreal was not abusive. So we can go to the next slide. So, our law in Quebec is very favorable to ADR, to arbitration, but in such case, the court said, well, that's going too far. What's interesting, though, and we can maybe go right away to the next slide, is that the court referred to a lot of institute models for arbitration clause. And really, the sticking point, as I said, was the fact that it was really not a flexible process. It was only to be in front of a 3-arbitrator panel. And the court really said that if it had been a sole arbitrator, it would have been fine. And that in cases where the parties do not know the scope of prospective litigation, there need to be flexibility in the drafting of the arbitration clauses, meaning that, and once again, referring to all kind of precedent from either the ICC or other institute, there is some way to have sometimes fast-track arbitration or arbitration clause that have triggers that will say, well, if let's say the litigation is beyond 1 million, it's one arbitrator, or above 1 million, it would be a panel of 3 arbitrator. And the court really put much emphasis on the fact that although ADR is really good, it has to be proportionate to the problem. And a good drafting would be to have clauses that give the parties flexibilities to have an ADR that meets the type of litigation they're facing. So that was my last case, and I think Arif is going to continue.
Thank you, Sébastien. Today, I'll provide an update on the common law duty of honest performance as it applies to pre-contractual negotiations and post-performance conduct. To set up the discussion, I'll quickly review some key principles regarding the duty of honest performance, but keep in mind, it certainly is not an exhaustive list. So I'll start with the decision in Basson. So in Basson, in 2014, the Supreme Court recognized for the first time the duty of honest performance as one manifestation of the organizing principle of good faith. The duty provides that contracting parties, quote, must not lie or otherwise knowingly mislead each other about matters directly linked to the performance of the contract. And the duty of honest performance is present in every contract. As we'll see on the next slide, in 2020, in Kaleigh, the Supreme Court clarified that dishonesty or misleading conduct can include half-truths, omissions, and even silence. The alleged breach must also be linked to a specific contract. On the next slide, we'll see that in Cresco, an Ontario Court of Appeal decision from 2023, the Court of Appeal confirmed that in the circumstances of a breach of the duty, there's no presumption of loss. And in short, the loss must be proven. So taking that as background, if you turn to the next slide, we'll see that Kaleigh did not unequivocally shut the door on pre-contractual conduct. And since Kaleigh, there have been some decisions that have commented on the issue, perhaps an obiter. There have been some decisions that have made some clear statements, but have little precedential value. And so this all came together and came to a head, as we'll see on the next slide, in a British Columbia Court of Appeal decision. It's called Ocean Pacific Hotels and Limited and Lee. This matter was a class proceeding that concerned former employees that had negotiated casual employment contracts with their employer to replace contracts of regular employment. So these circumstances arose during the COVID pandemic, and at that time, obviously, hotels were struggling and people couldn't stay in hotels. And the employees entered into these casual work agreements during around July or August of 2020. And so while the employees would not receive regular shifts, they gave up the right to severance pay, they were advised at the time that they would be able to receive extended benefits through the employer's insurance carrier. So they signed these agreements in July or August, depending on the person, of 2020, but by January 2nd of 2021, the benefits had terminated. It turned out that the employees had only received coverage until January 1st, 2021, sorry, January 2nd, since it was a grace period for them. Next slide. So a class action was commenced, and the allegation was that the employer was dishonest when negotiating the casual employment agreements, and that dishonesty regarding the extended benefits induced entry into those casual employment agreements. So casual rather than full-time employment. And what the plaintiffs did was they asserted that the original employment agreements and the casual employment agreements should be considered together holistically as one agreement, and that the plaintiff had been and that the hotel had been dishonest during the course of the original employment agreement. Next slide, please. So the court canvassed various authorities, including one that I worked on, and while the court conceded that Bazin and Callow did leave open the possibility of the duty of honest performance applying to pre-contractual conduct, and the Supreme Court hadn't made any clear pronouncement on that, the court did decide that dishonest conduct in the course of pre-contractual negotiations, which were intended to induce the formation of a contract, can't form the basis for a breach of the duty of honest performance. The conduct was not tied to any sort of performance. The court also rejected this notion that the original contract and the casual contract should be considered holistically together. And so in the class action context, the Court of Appeal here concluded that because the conduct had been pre-contractual, that claim was doomed to fail, and that issue should not have been certified. Now, we shouldn't take this to mean that there's no relief for pre-contractual dishonesty. There's relief through negligent or fraudulent misrepresentation, which the court acknowledged. Just go back to the previous slide, please. So, it matters where this mattered in this circumstance because this was a class proceeding. In a class proceeding, misrepresentation, negligent or fraudulent, is very hard to certify as a common issue. So the class had to assert something else in respect of the pre-contractual allegations that they said were misleading. Now, again, there's the possibility of fraudulent or negligent misrepresentation, and there could also be a circumstance conceivably where pre-contractual negotiations could give rise to a breach of the duty of honest performance. It's not come up yet in appellate authority, but I could conceive of some things like that. Perhaps an example might be lease negotiations where you have to renew or you have to assign potentially to a prospective new tenant. So that's not been addressed yet by appellate courts, but the general takeaway from Ocean Pacific is that pre-contractual negotiations will not be subject to the duty of honest performance. Next slide, please. And during 2025, courts also considered post-performance conduct. And in particular, there's a decision, Heritage Property Corporation and Trivest, which is a 2025 decision from the Alberta Court of Appeal. And this, amongst other issues, considered whether or not there could be a breach of the duty of honest performance after performance had concluded. In this matter, the appellants needed two things to proceed with a development project in Calgary. They needed one, rezoning, and two, a development permit. The respondent in this appeal wanted to acquire a parcel of land from the appellant that the appellant didn't need for the project. And so they entered into a purchase agreement for that parcel of land, one of the terms being that the respondent would provide a letter stating that it did not oppose the rezoning. So the contract was silent on development permit. After the land had been sold, the signed letter given by the respondent, later, the respondent went on to challenge the development permit application for this project. In that circumstance, the appellant claimed that the respondent, by challenging the development permit application, had breached the duty of honest performance. So in this case, they said that opposing the project generally would be a breach, despite having already provided the letter confirming that the respondent did not oppose rezoning. Next slide, please. The court went on to conclude that the general organizing principle of honest performance does not expand a specific obligation into a general one. So in this case, providing the letter saying that they did not oppose the rezoning could not lead to a larger obligation not to oppose the project generally. And so once the letter had been given, there was no further performance under that contract for the sale of the land. And there was no obligation engaging the duty of honest performance. The respondent was free to oppose the later development permit needed for construction. The court commented that the duty of honest performance is unlikely to operate where the alleged dishonesty occurs after the contract has been performed. It leaves open still that there may be rights and obligations, and there often are, that survive the conclusion of performance of a contract. And those rights and obligations that survive might still be subject to the duty of honest performance, but that is for another day. Next slide, please. So if I can summarize the duty of honest performance and the bookends to it. So there's a duty of honest performance in contract. That duty must be linked to specific contract performance, and that duty can include omissions or half-truths or things like that. There's no presumption of damages for breach of the duty. And as far as pre-contractual conduct, the duty generally will not apply to pre-contractual negotiations used to induce a contract. And as far as post-contract performance, the duty is unlikely to operate after the contract is performed. There's still some nuances that remain to be explored. This is an evolving duty, and as I mentioned, there could be circumstances where pre-contractual negotiations could be subject to the duty, and there could be circumstances where post-performance obligations could still be subject to the duty, but those have yet to be explored by appellate authority yet, and we'll leave that for another day.
Great. I think that brings it to me. I'm going to report on two cases out of Ontario. If we just want to go to the next slide. One is a case that went to the Supreme Court of Canada. They both deal with issues of contractual interpretation, and if I could draw a common theme between the two, it's that freedom of contract still remains a thing in Canada. I think some people's response to the duty of good faith case law that Arif was just talking about is that the court is really getting in and intervening in parties' freedom of contract by imposing these obligations across the board. These two cases are kind of the counterpoint that they don't specifically deal with the duty of good faith. One touches on it, but freedom of contract is still a thing. The court will only go so far to intervene where the parties have sat down, chosen words in a contract, and chosen what their respective rights and obligations are. That may be good or bad. We'll see in the first case that one of the parties was essentially left without a remedy because they didn't make it clear enough in the contract. So if we go over to the next slide, the first case I want to talk about is the Royal Bank and Peacebridge case out of the Ontario Court of Appeal in 2025. And just very briefly on the facts, it was the Peacebridge duty-free store. So they ran a duty-free shop at the Ontario border. COVID pandemic hit. Obviously, their business was majorly impacted, and it sought rent relief from its landlord, arguing, using a term of the lease, which we'll look at, that there was a material impact on their business, and they were entitled to a reduction in its rent payments. What the provision required, which we'll see, is ultimately that the parties consult, that when there is a material adverse impact, the parties consult on what that means for rent. Arguably implied in that is that, if the business goes down, the rent payments will go down. But it didn't actually provide any provision by which that rent abatement would be calculated or determined. And so what ultimately happened was the parties consulted, they got together, they talked, couldn't come to an agreement on what the new rent would be. The Peacebridge ultimately applied to the court and asked the court to set a court-imposed rent abatement or adjustment. And at first instance, the motion judge refused to do that, saying, the clause doesn't necessarily mandate the imposition of a rent adjustment. What it mandates is the parties consult. But if the parties' consultations don't reach agreement, there's no basis for the court to step in and do that. And therefore, the landlord was not in breach of the lease provision. I think this really hits home when you look at the provision. So if we look at the next slide, it sets out the precise language as to what the lease provision required. Talks about regulatory changes that have a material adverse impact. But then the important language, which is bolded and underlined, the landlord agrees to consult with the tenant to discuss the impact of such introduction of or change in applicable laws to the lease. And so what the court was essentially dealing with was, what does that require of the parties? And as I said, the motion judge said, well, it requires consultation. The landlord consulted. It doesn't require agreement. Therefore, the landlord did what they had to do. And the fact that there was an agreement is unfortunate, but there's no way for the court to step in and intervene. It ultimately gets up to the Court of Appeal. And as we go to the next slide, what we will see is the Court of Appeal agrees, basically using the same analysis that the motion judge adopted, that while the lease obliged the parties to negotiate abatement, there was simply nothing in the contract or in the contractual language that permitted the courts to step in and determine what that abatement would be. It would essentially be a rewriting of the lease, which the court is very hesitant to do. Court of Appeal made the point that there were alternatives here, right? The parties could have included a mechanism for establishing a rent adjustment, or what is to happen if the rent adjustment cannot be agreed upon. You could, submit that to an arbitrator, an expert. You could you could give the court the power to set the rent abatement, but it didn't do any of that. It just required consultation and then was silent on what is to happen when there's no agreement. And one of the interesting points when it comes to sort of general contractual interpretation that comes out of this case is the discussion about the role of surrounding circumstances. So, courts have, I think, over the past couple decades, expanded their willingness to look at what they call the factual matrix, or surrounding circumstances, being the facts around the time of contract that exist and are known to both parties, in helping to interpret it. And there's been a debate in the cases as to whether that goes so far to permit the court to look at the facts around the negotiation of the contract. So, party A sent an email saying, we've introduced this clause. Here's what the purpose for it. Is that a surrounding circumstance, or is that evidence of subjective intent as to one of the contracting parties? The tenant in this case had some pretty good evidence that suggested that the whole purpose of the provision was, if the business goes down, the rent payments go down. But the court didn't accept that and said that that's not surrounding circumstances. Surrounding circumstances have a limit, and they can't overwhelm the words of the contract. So where the contractual language isn't consistent with what you want us to do, we can't then use surrounding circumstances to find that power. At the end of the day, it's an agreement to agree, and the court's not going to step in at that point. On to the next slide. The case touches briefly on good faith concepts. I'm not going to go into it because Arif has touched on this, but basically it's another case that can be used to suggest, look, even if you have the duty of good faith in the course of performance, you don't have to set aside your own economic interests. You can still be aggressive in protecting those interests. You just have to be fair to the other side. So the key takeaways, I think, are, precision in contracts is still super important. An agreement to agree is not going to be enforced by the court, and they're not going to step in to rewrite the contract. And if you're in the course of negotiating a contract and you think you've negotiated a particular right, such as a right to a rent abatement, you better look at the contractual language and make sure that that actually goes so far to say you have that right. Even if the emails back and forth suggest everybody's on the same page as to what will happen in that circumstance, if it's not actually in the words of the contract, you're leaving a bit of uncertainty where the court may or may not step in. So on to the next case out of Ontario that I want to discuss. It's the Earth Coast Soil case, which made its way up to the Supreme Court. It deals with the Sale of Goods Act and implied conditions in that act. It comes out of Ontario, but I think all provinces other than Quebec have similar legislation. And the discussion could get a bit technical on Sales of Goods Act, and I'm going to try and keep it a bit high level for the more general provisions. But for those who don't deal with Sale of Goods Act statutes on a daily basis, there's a number of implied statutory conditions under the Act that are applied anytime goods are sold, or can be implied anytime goods are sold. Very common ones are, there's an implied condition that goods are fit for the purpose for which the seller intends to use them, or the buyer intends to use them, sorry. There's an implied condition that fits are of merchantable quality. And these are things we see that when, the good doesn't do what it's supposed to do, when it breaks down, when it doesn't perform. These are statutory conditions that people rely on to say, we have a right to sue you. The important thing is the statute, at least in Ontario, and I'm pretty sure in most other provinces, provides the ability to exclude the statutory conditions if the parties agree to do so in their contract. What we've seen in the cases is the courts have been pretty reluctant to uphold exclusions of the statutory conditions. They've required great specificity on what you have to say to exclude the statutory conditions. And it's kind of, I often attribute it to akin to what some of our employment colleagues deal with in termination and severance provisions, where you've drafted what you think is the perfect provision, and then it goes to court and the court finds a way around it, and then you rewrite the provision and now it looks perfect, and then that one goes to court and the court finds a way around it. There's just been a general reluctance to uphold exclusions of these statutory conditions. If we go over to the next slide, I'm not going to go into the specific conditions that were applicable here. I think we can actually skip to the next slide to get to the outcome. The trial judge first upheld the exclusion clause and said, well, the parties have said that. So one fact that's important is that the buyer had a right to inspect the goods here. And there was a provision that said, well, if the buyer doesn't inspect the goods, then the seller's not responsible for the quality. And the trial judge looked at that and said, well, that's an exclusion of liability of any implied conditions under the Sale of Goods Act. And so therefore, there's no liability. Court of Appeal disagreed. It relied on the principles I was talking about earlier about it not being sufficiently precise, sufficiently direct to exclude liability under the Sale of Goods Act. Supreme Court comes in and ultimately goes back to the trial judge's decision, finds that the exclusion of liability was sufficient. And what's important is it basically said, look, there's been all this case law that says you have to be pretty precise in how you exclude liability under Sale of Goods Act contracts. There's no magic words, right? What it requires is that the parties expressly excluded the application of the condition. And when you're assessing that, what you look at is the things you typically look at in interpreting a contract. You look at the words used, you look at the surrounding circumstances, you look at the nature of the contracting parties, whether one may be unsophisticated, and you just make a determination on all that, whether the contract excluded liability. And here they found that the buyer clearly accepted liability or accepted risk where they didn't inspect the goods. So the major points on that is, Sale of Goods Act, I've always considered a bit of a exception to general contractual interpretation because the courts have taken such a different approach to it. I think we're now back into a world where the general contractual interpretation provisions will apply. If your company is in the business of purchasing or selling goods, take a closer look at your limitation of liability language or the other side's limitation of liability language, because it's more likely to apply going forward. And it's still, as with any contractual issue, it's still best practice to be as clear as possible, because even at the Supreme Court, there was a dissent where Justice Cote found that the language wasn't clear enough. So it's been before 3 courts, multiple judges, still disagreement. Precision in contractual drafting will still win the day. And that's my update on Ontario. And I think I'm going to turn to Kaleigh for BC.
Okay, we finally made it to the West Coast. Thank you so much, Jesse. So there's been a lot of exciting things that have gone on in BC in the last year, but I'm going to control myself and focus on just one case this morning that I hope will be of general interest and application to you all watching at home. And that is the BC Court of Appeals decision in Max Convenience Store Inc. and Basiol. That case focuses on the law of agency, which is an important topic that is very often misunderstood, and its results are profound. If you are found as a principal to be in an agency relationship, you're responsible for what that agent goes out and does on your behalf, and that. The scope and existence of an agency relationship was at issue in this case, which is a class action proceeding that involved the recruitment of temporary foreign workers. So Max Convenience Store Inc., the appellant, now Circle K, was having difficulties recruiting workers for low-wage positions in their operations, and intended to use the temporary foreign worker program to bring people to Canada, as so many Canadian employers do. And they hired a third-party immigration firm called Overseas Immigration. And so the basic background is that Overseas hosted job fairs in Dubai, and there were a number of other Canadian employers that hired Overseas to do the same thing. And so the prospective workers who form the class members in this case attended the job fairs and paid very significant fees of some $8,000 to Overseas for what Overseas says are immigration services, and the plaintiffs in the class action say are illegal fees for jobs. So Max is hired Overseas. They have no idea that Overseas is charging these fees. And the trial judge finds ultimately that Max is vicariously liable on the basis of an agency relationship for these significant fees. And so the issue on appeal is whether or not the judge erred in concluding that the immigration consultant was Max's agent in recruiting workers. So on the next slide, the Court of Appeal starts its analysis, which ultimately concludes that the judge was wrong in her approach to the law of agency by answering the question, what is agency? And so the key points that come out of this definition are that to be an agent, you have to be empowered by your principal to affect their legal position by either contracting or disposing of property. And on the next slide, just by way of basic refresher, I've excerpted from the court's reasons the two different types of agency that exist. The first is probably well known to all of you. It's actual authority. You're entering into a contract, a principal agent contract, where you're expressly empowering someone to contract on your behalf. And oftentimes the cases in those circumstances are looking at the scope of the agency and what the deal between the parties actually is. There's also apparent authority, which comes up very often in broker cases where somebody is, for example, putting out a mutual fund broker who's sitting at a desk somewhere selling mutual funds or insurance, and they've got the sign up of the company, and somebody comes to buy the policy. And while that broker may be selling for a number of different people, they're perceiving to be contracting with that broker on behalf of the company, and issues come up sometimes when people go rogue. But the key point there is that the principal is representing to the world that this person has the power to contract on their behalf. And an agency in some circumstances can be formed on that basis. And in this case, the judge found that both actual and apparent agency authority existed. And on the next slide, the key error of the trial judge is exposed. So the judge's reasoning is in its essence treated the fact that Max put out this immigration consultant to do something on its behalf, to recruit workers. That was enough to found an agency relationship. And what the Court of Appeal focused on is that, so often we're throwing around the word agent, but what does it really mean? And so the court focused on the fact that just the colloquial use of the word agent creates a lot of confusion. And to be clear, the parties here hadn't used the word agent. There was no written agreement between them that would have given rise to that result. The court focuses on the fact that the essence of an agency relationship is the power of the agent to affect the legal position of the principal by entering into contracts that bind the principal. And so on the next slide, I've set out a bit from the court's reasons that reflect this error. In circumstances where someone is doing something on your behalf for a purpose, that's not good enough to convey the significant consequences of an agency relationship. Here, being responsible for the large amounts of fees paid by the class. What's needed for agency is the power to contractually bind. And it was critical in this case that Max had reserved the ability to contract. In other words, the immigration agent wasn't going out with a blank check to hire people. Max was conducting the interviews, signing the offers, and the agent was merely conveying the offers back and forth. The immigration consultant didn't have the power to contract that the court found was essential. So on the next slide, I've set out a few key takeaways. The decision, if you're sitting in the perspective of someone, as I expect many of us on this call are, trying to limit the scope of a purported agent or trying to limit the scope of liability, this decision is a helpful confirmation of what is required to prove an agency relationship and takes a narrow and precise view. The second main takeaway is that it's important to the extent possible to define the scope of authority, in your business that you're giving to other people clearly. Here, Max had through the use of the temporary foreign worker program, signed off on a document that said they would agree to be responsible for anything the immigration consultant did. That was a condition of participation in the program. But the court still rejected that as good enough, rejected it as not good enough to get to the result that the plaintiff sought, because again, it didn't confer that contracting power. So it couldn't have the meaning that the plaintiff sought. And I should pause to note that agency, of course, is one species of vicarious liability. I expect, as many of you will know, there's a different test that applies when you're looking at vicarious liability for employees. That's something different, as well as contractors. So here, this case really is addressing the place of a consultant or a recruiter or someone who doesn't fit into the employee contractor box. And really the main takeaway is set out in the last bullet, that simply sending someone out into the world to do something for you is not enough to create an agency relationship. And the trial judge's conclusion that would create an agency relationship is wrong and would cast a broader net of all kinds of relationships in society where an agency isn't intended. So that takes me through our presentation, and we've left just a few minutes now. If anyone wants to drop a question in the chat, we've got the Q&A feature set up if there's anything that you're left wondering after our presentations. Okay, seeing none, I'm going to take the initiative to put my co-presenters on the spot, Jesse and Arif. So listening to your presentation, we hear so much about the duty of honest performance. Anyone who works in commercial litigation sees it constantly in pleadings. We also have the overlap with general contractual rights. What does it add to a contractual dispute? Like, can you give us a sense of when the duty of honest performance might truly matter in a claim?
Go ahead, Arif.
No, thanks, Jesse. I think the duty was added when there was, if you look at the facts in Basin, there was nothing else available. And it was something where the court felt like they needed to address and ensure justice. And so I think what it adds is just kind of a minimum baseline of expectations, which are applicable in any contract. You're not able to contract out of it. It's clear it's not an implied term. So it just gives a baseline where if you truly are dishonest or misleading, a court can still intervene to assist.
I was going to say it adds a lot of uncertainty because I think the court, like the Supreme Court, came out with the principle, and the courts below have been trying to figure it out for a while now. The one area that I often think about it in areas that I think it could be a big risk and also use strategically as a litigator is situations where a party may have complied with their strict contractual rights, but still were dishonest in doing it. Like we saw that in Kaleigh, where they just didn't renew the contract, or they might have had termination for convenience. I don't remember, but a situation where the contractor had no expectation of getting a subsequent contract, but maybe they misled him a little bit. And so contractually, there was really no case there. But because of the way they went about it. So that's something I've been talking to clients about, that when it comes to termination, even if you have termination for convenience, you want to be pretty careful about the communications, what you're saying to the other side, how you're enforcing those contractual rights, because even if you're onside your contractual rights, you may be offside the duty of honest performance.
Great. Thank you. Thank you both so much. That's very helpful. So that takes us essentially to the end of our time today. So thank you everyone so much for tuning in. You'll see the information for how to claim your CPD credits, which are becoming increasingly important as we get to the end of the year. And if you don't get a chance to claim your Ontario and Quebec certificate today, I understand they'll also be sent next week, and that we have some links in the audience chat as well. So thank you all again very much for tuning in. And I see we've just had a question come in. So thank you, Andrea, for flagging that. So the question, I think, is again aimed at Jesse and Arif, and it is, can the duty add aggravating circumstances and therefore larger damages?
So I would say yes, that a breach of the duty, if there's a breach of performance, that's something set of some term in the contract, but there's also an element of bad faith to it or dishonesty to it. I would say that additional breach can open the door as a threshold issue to perhaps not aggravated, but punitive damages. Because aggravated damages in a commercial context should be things like mental distress or things like that, which are not really common in a commercial context, but I would say it can open the door to potentially punitive damages.
Yeah, that makes sense to me. And I would think also in the employment context, if there's bad faith in the manner of termination, that also might link to a claim for aggravated damages.
Yeah, I think, it's another area the courts have struggled with. Like in Kaleigh, they essentially gave expectation damages, which doesn't make much sense to me. And that's why we see the Ontario Court of Appeal case that Arif mentioned, which the name escapes me, but that's, I think, the case that is dealt with. What does this mean for damages head on? And it basically said, well, there needs to be something more. There's no presumption of damages. You need to show that something has resulted from the breach of the honest performance, but it's pretty opaque what this means for damages right now, in my view.
And Jesse,
if I may, Kaleigh.
Sorry, Sébastien.
So for everyone's benefit, the concept of good faith has been introduced, duty of good faith in Quebec in 1994 in our civil code, and everybody was freaking out at the start, and we had a lot of conference and a lot of cases where it was dealt with, but I can tell you that it has been dealt with extensively. But at the end of the day, the court will not, in Quebec, what we've seen is the court will not intervene unless there's something very egregious. And because they will rely on the contract, and the contract is as Jesse said, is still the law of the parties. And as for damages, in Quebec, the way it has been dealt with is if the breach of the duty of good faith has created specific damages, that then you can get those damages, but it has not created another layer or level of damages on top. You still have to prove your damages. And obviously, if we take a case of termination, if a guy just bought a snowplow just before not being renewed to execute the contract, well, then he might probably be claiming the costs he incurred. But it's still a matter of proving your damages and having causation with the breach of duty of good faith.
Okay, and we have one more question, if we can just keep everyone a minute longer, and it's a follow-up point for Jesse. So Jesse, in your assessment, would you advise staying silent on the reason for termination, or would you advise being more particular? I appreciate that may be context specific, but is there any general reflections you can provide?
Yeah, you're right. It kind of depends. My view is, as these concepts are developing in the cases, both the duty of honest performance and the duty to exercise contractual discretions in a way that's not arbitrary or capriciously, promotes an approach where if you have good reasons for termination of the contract or good explanation for why you're taking those steps, I think adding that can be beneficial. There's obviously risk there, right? And what you certainly don't want to do is tell them that we're terminating because of X, Y, and Z when you know that it's because the CEO doesn't like the other side's haircut, right? Like, so if you're purely just relying on your contractual rights and saying, hey, we have a termination for convenience, we don't like you and we're terminating, I would be silent. But I think the more that there are situations like, the service levels haven't been great, performance isn't there, we have a right to terminate for convenience, we're also facing all these issues, we're not being a big bad company, we're trying to be nice. I think that could put you in a better position, but you want to be 100% certain on the messaging that's going out. So my core messaging to clients has been, think about who's sending termination letters. Like it may have happened at a lower level of the organization than it should now. It may be something that you want to have legal eyes on rather than just have it be your contract management team. Because there's, these questions aren't an easy yes or no, and it takes a lot of consideration.
Fantastic. Very helpful stuff. So I think that takes us to the end of our time together. Thank you again, everyone, for tuning in and for your helpful questions. And we wish you all a great day.